know what she said, she might just change your life.
And it is The Legal Beat with Joseph A. Neuberger and Partners LLP. Plain talk about legal, liberty, and social justice issues that impact all Canadians, what we need to know and want to talk about. And today, Joseph, we are talking about a lot of things.
Stuff.
Why don't we start with the easy one, which
Sure.
is Marco Muzzo, granted bail.
Yeah.
And lots of talk about, you know, he was granted bail, and in fact, that's not unusual. That's pretty normal.
No, he would have got bail originally, so after his arrest, within a few days, if he wanted to, he could have easily sought bail and would have been able to post a bail and get out, and would have been able to assess the evidence with his lawyers while out of custody. He chose to stay into custody, which most of us speculated was because this was going to be eventually a guilty plea based upon some resolution. But Brian Greenspan wanted to review the evidence to do his due diligence. And now that guilty pleas have been entered, what's not uncommon in a case where somebody's going to go to jail for a number of years, they're going to ask to get out on bail for a short period of time to really put their affairs in order, you know, hang out with your family a little bit, that stuff. And then he'll step into custody when the sentencing occurs, I think, on the February 23rd.
Now, I understand their impact, victim impact statements being read.
Yes.
How crucial are those in sentencing? Because to most of us, it's self-evident.
It's absolutely self-evident. And there's been provisions in the criminal code for victim impact statements for a long time. And it's to give victims and family of victims an opportunity to have a voice and be heard, because they want to feel that the justice system takes into consideration what they have to say and what they're going through. But the reality is it's not lost on either the prosecutor, the defense, or the judge. Everybody understands the enormity of this tragedy. But it's a good opportunity for them to speak and feel that they've been heard. And when the sentence is rendered, you know, some may say it's not a fair sentence, it's not long enough, and so at least it's an opportunity to speak and be heard.
Okay. So, shall we move on now
Oh my.
to the one that everybody, of course, is talking about daily, by the hour, which is the Jean Ghomeshi trial. So.
Right. Well, you know, it's interesting. I think, you know, from my perspective as a defense lawyer, what I find most interesting is that everybody thinks it's that interesting. Because we're dealing with a celebrity, and this has been high profile. A lot of the allegations were in the public domain through interviews well before, of course, this ever came to trial. So that makes it very interesting. But some of the evidence you're hearing in cross-examination is not uncommon as to how we deal with these cases in the courts. And you'd be quite surprised, I guess, or the public would be quite surprised, that this is very common. This is how you cross-examine. There are 20 files in my office, and 3 that were withdrawn already recently that had to do with post-assault conduct, where there was a plethora of evidence of an intimate bonded relationship that sort of defied the allegations in the first place. So it's being a bit more dramatically played out right now for obvious reasons. But, you know, it's a stark example of why there are serious issues of credibility in many cases, because, you know, for years people keep relationships and they keep in contact and maybe they continue to date, and then at one point there's an allegation of a sexual assault, and you really got to look at it in light of the conduct over the last several years that was after this sexual assault, or the alleged sexual assault.
And what about people talking about the re-victimization of victims when in actual fact there was not one objection to Marie Henry?
No, the cross-examination is perfectly professional and is what is necessary to defend somebody. The Crown bears the obligation to prove a case beyond a reasonable doubt. So, I understand what re-victimization is, but as I've said before, across the country, lawyers don't badger witnesses. They run intelligent surgical cross-examinations that deals with the evidence. And the flip side of this is, if we didn't cross-examine complainants who allege sexual assaults, how many wrongful convictions might we have? I mean, this is the criminal justice system. It has to strike a balance between victims' ability to come forward and talk about allegations that in many cases are legitimate, but also allow for a fair trial and an ability to defend yourself and have the allegations proved beyond a reasonable doubt. So this isn't re-victimization. This is a person testifying, and they're facing very serious questions about conduct, which is not really congruent with the allegations that they're suggesting.
My, I guess, observation was that the Crown had some issues to deal with finding out not knowing ahead of time that about emails and about, you know,
Well,
That seems so odd, doesn't it, though?
It's
and
not, like,
and a
it-
complainant saying, "Well, I didn't know that whatever I happened after had any impact." I mean,
right, it defies common sense, right?
Yeah,
You're
it
having a
does.
hard time listening to that because it doesn't make sense to you. But this happens all the time. I mean, to give an example, I had a case, again, it arose out of a bad divorce, where there's these allegations of historical sexual contact, and the complainant says very clearly in the statement, on this date, that was the last time we had relations, that was the last time, nothing happened after it, absolutely not. And my client had videos. They used to love videotaping themselves. Videos for months afterward, right? And, you know, I had to have my associate watch it because I was so embarrassed watching them. But the reality is it completely defied the allegations. I brought an application, because there's something called Section 276. I brought an application, disclosed it to the Crown. The Crown didn't withdraw at that point. They wanted me to proceed with the prelim, but that was the end of the case. So you might say, how did that complainant not mention it to the prosecutor or the investigating officers? I have no idea. I don't know why. And, you know, maybe legitimately some complainants may feel that whatever conduct they had afterward is not relevant, but it is. It's extremely relevant.
but you would think that if you had gone first to the press,
Mm-hmm.
and then you had hired a lawyer and you were pressing charges,
Yeah.
that you would give your lawyer
Everything.
and let
Yeah.
him or her then use whatever they needed.
Yeah, well, first of all, this is a prosecution, so the Crown prosecutor is not their lawyer. He's prosecuting on
but-
behalf of the government.
Right.
So, and they have their own civil lawyers, but I think the civil lawyers are in the dark as well. There's some evidence or some information that one of the civil lawyers had called up the Crown's office about what after-the-fact conduct existed. But let's talk about interviewing for a second, okay? So what goes on in an investigation like this? We got to think for a moment carefully about this, okay? A complainant comes forward and says, 6 years ago I was sexually assaulted when I was dating so-and-so. Okay. What does an investigator do? They sit down, they take a statement. What else can they do? You know, physical evidence is gone, there's no injuries necessarily to rely on, there's no photographs of injuries, there's no medical reports. You know, so what do? They're interviewing. The interviews have to be very detailed, probing interviews, and one may say, well, we don't want to re-victimize through the interviews, but, you know, you might want to ask, well, after this happened, what was your relationship like? Did you carry on your relationship with Mr. Gomeshi? Did you continue to see him? Did you communicate with him? I find social media to be an unbelievable source of information when I do a defense investigation. I get tons of stuff. There's emails, there's contacts, there's postings on Facebook. It's amazing. Pictures posted of going to restaurants or going to a play, and it's completely contrary to the allegations themselves.
So where did this sort of fall down? In the investigation, or were they not forthcoming, or
I don't
who
know.
knows?
I
Who
don't know. I
knows?
mean, you know, I assume
But
the
that
officers
that
did.
the Crown was surprised by it, maybe?
I just think if I were a complainant, I would want cards on the table.
Yes.
Like, just everything else. Here we go. This is it.
If you're trying to tell the whole story, then you would say, look, this was my dynamic with him. This is how long we dated. This is what we did. I, you know, felt I was, you know, violated, but I still wanted to date him. Maybe I could understand it more. Maybe our relationship would change. And then you can put it into some sort of perspective, because there are victims who react differently than you and I may think in a
Absolutely.
rational
No,
way,
absolutely.
and may stay in relationships. But then explain it
Exactly.
in your statement, explain it in your evidence in chief, and, you know, put some context and coherence to it.
It would be far more
And it didn't-
effective. Then you're not reacting.
Absolutely. You're now caught.
Mhm.
You know, it's like the first witness who said, no, I absolutely never had contact, and there's an email of her in a bikini. I mean, again, I'm not trying to denigrate the evidence or the pain maybe that these victims say they have, but it just doesn't seem to have the ring of truth when so much has gone on afterward and they have not disclosed it.
But you do have a point when you say that people react differently, and I can certainly understand it. It might not be what I would do, but I can certainly understand somebody maybe wanting to go back because they don't understand why somebody treated them a certain way. So they
Yeah.
want to maybe see if
Right.
they can, you know, spend some time with that person or something.
Or
to see-
depending
Yeah.
on the woman. I mean, there's the whole either battered woman or abused person syndrome that
Yeah.
can come into play.
You know, if somebody's in a relationship where they are more marginalized, they don't have access to, you know, other supports and people, you know, we're dealing with very different circumstances, and that may explain why somebody stays in what is otherwise an abusive relationship, and we know that. But, this witness who's testifying is a captain from the armed forces, is a well-known actress, obviously has lots of support, intelligence. One might imagine that she would explain in her statement all of the dynamic and ongoing details of their relationship in order to give prosecutors and the police a more detailed, holistic set of facts in order to assess a case. And when you hold that back or say, I didn't think it was relevant, that's just not, it's not good. It's just not good.
And we are in discussion with Joseph Neuberger on The Legal Beat on What She Said, SiriusXM 167 Canada Talks. And, of course, we want to move on as well to talk a little bit about the Tim Bosma story and trial.
Okay. Well, that's just progressing slowly. It started off with his wife setting up the scene and the oddity of these people coming in, and now they're trying to link certain pieces of evidence to it. It's going to be a long trial. It's very high profile. It's extremely tragic. It's a bit odd given one of the accused with the wealth and background of that person, but they've been charged with now allegedly killing his father and a girlfriend. So it's very captivating that way. But it's going to take time for the Crown to lay out the case and systematically go through the evidence in order to establish the identity and link them up to the murder. And it may seem pretty obvious because that's the disappearance right after when they came and went on the ride with the car. So very sad case. It's going to take several weeks.
Yeah, I see this as a horribly, but a movie in the down the road.
It is, and what
because we don't know the motive, and I guess maybe we may never.
No, you may never. People, who knows why people do things or commit crimes, but there's a lot of with Kijiji ads. There's been Kijiji robberies. People are selling cell phones on Kijiji and various other things, and they meet somebody in a certain location, they get robbed. These things do happen. So what it does say, cautionary to people, is you've got to be very careful about what you're doing via the internet to sell to individuals and who you're going to meet and what circumstances you're going to be in, because you could be quite vulnerable. And we don't know when people are having nefarious motives and ideas.
It's true, and I think that's why we're also drawn to this story. It could be any of us.
It could be, and it's very sad, and it'll be the Crown is going to take its time and carefully lay it out in a detailed fashion in order to pin down the identity and to secure conviction.
Are you expecting a surprise down the road? Because there's a part of me that feels that one day some information's going to come out, and then we're all going to go, oh, now I get it. I don't know.
I don't know.
Because it's sort of bizarre.
It is, but yesterday they had the gentleman on the stand who was out for a test drive the day before.
Right.
With those two.
Right.
And, what that does or doesn't do for the case, I don't know, but as someone who was seeing the news story, I thought, that guy's got to be just shaking his head and saying, wow, just but for the grace of God go I.
Yeah, you don't look, people do horrific things for all sorts of reasons, and we don't know. Now, I think what we have to do is let the case progress. They are still presumed innocent. Let's remember that. This is a fair trial process, so let the evidence flow, let the Crown do whatever they're going to do, and the defense do what they're going to do. And at the end of the day, if they secure convictions beyond a reasonable doubt, then we can sort of talk about what the evidence really says about this offense and why it occurred.
And we are in discussion with Joseph Neuberger on The Legal Beat on What She Said, SiriusXM 167 Canada Talks. And, of course, we want to move on as well to talk a little bit about the Tim Bosma story and trial.
Okay. Well, that's just progressing slowly. It started off with his wife setting up the scene and the oddity of these people coming in, and now they're trying to link certain pieces of evidence to it. It's going to be a long trial. It's very high profile. It's extremely tragic. It's a bit odd given one of the accused with the wealth and background of that person, but they've been charged with now allegedly killing his father and a girlfriend. So it's very captivating that way. But it's going to take time for the Crown to lay out the case and systematically go through the evidence in order to establish the identity and link them up to the murder. And it may seem pretty obvious because that's the disappearance right after when they came and went on the ride with the car. So very sad case. It's going to take several weeks.
Yeah, I see this as a horribly, but a movie in the down the road.
It is, and what
because we don't know the motive, and I guess maybe we may never.
No, you may never. People, who knows why people do things or commit crimes, but there's a lot of with Kijiji ads. There's been Kijiji robberies. people are selling cell phones on Kijiji and various other things, and they meet somebody in a certain location, they get robbed. These things do happen. So what it does say, cautionary to people, is you've got to be very careful about what you're doing via the internet to sell to individuals and who you're going to meet and what circumstances you're going to be in, because you could be quite vulnerable. And we don't know when people are having nefarious motives and ideas.
It's true, and I think that's why we're also drawn to this story. It could be any of us.
It could be, and it's very sad, and it'll be the Crown is going to take its time and carefully lay it out in a detailed fashion in order to pin down the identity and to secure conviction.
Are you expecting a surprise down the road? Because there's a part of me that feels that one day some information's going to come out, and then we're all going to go, oh, now I get it. I don't know.
I don't know.
Because
I mean,
it's sort of bizarre.
It is,
right?
but yesterday they had the gentleman on the stand who was out for a test drive the day before.
Right.
With those two.
Right.
And, what that does or doesn't do for the case, I don't know, but as someone who was seeing the news story, I thought, that guy's got to be just shaking his head and saying, wow, just, but for the grace of God go I.
Yeah, I mean, you don't look, I mean, people do horrific things for all sorts of reasons, and we don't know. Now, I think what we have to do is let the case progress. They are still presumed innocent. Let's remember that. This is a fair trial process, so let the evidence flow, let the Crown do whatever they're going to do, and the defense do what they're going to do. And at the end of the day, if they secure convictions beyond a reasonable doubt, then we can sort of talk about what the evidence really says about this offense and why it occurred.
Okay.
No Bill Cosby?
Oh, yes, we're going to talk about Bill
Because
Cosby.
of all
Cosby?
the issues, I
Yes,
find this to be
we are.
extremely interesting.
This is interesting.
Yeah.
I mean, well, my understanding is he says he made a deal,
Yeah.
and the judge said, too bad.
Yeah, and the former district attorney testified. So this is really, really interesting. So, and it sort of makes some sense now, because when I look back at the flow of information, we know that in 2005, that district attorney decided not to prosecute, and they made a public announcement about it. Then Cosby proceeded with defending the lawsuit. And in that lawsuit, he attended for depositions, what we refer to in Canada as discoveries.
Right.
And during those depositions, he made certain admissions that were quite damaging. So that he obtained quaaludes to give to women who he wanted to have sex with, although he maintained with this particular lady that it was consensual. However, one can argue if you're giving a drug that sedates, that could vitiate consent. So these are very serious admissions. So if you do not have a deal for non-prosecution, you would not, in the United States, waive your right to not give evidence,
Right.
and you wouldn't subject yourself to giving that type of incriminating evidence. So obviously the lawyers must have felt and relied upon some sort of non-prosecution agreement, which I thought was very interesting. But the judge said, it's not in writing, there's no immunity agreement in writing, and whatever this prosecutor did, it's not binding on all prosecutors in perpetuity.
That's where my question went. Would this not be documented somewhere?
Well, it should be. In the United States, they have these immunity agreements, and if it's not going to be prosecuted for the future, you want to make sure you document it properly. In Canada, we often have decisions made by prosecutors not to prosecute. We don't have them so much in such high-profile cases, but we rely upon the word of the prosecutor. But in very specific cases, if you go back to the Carla Homolka deal,
Yes.
that was in writing.
That was in
Right,
writing.
because that's high-profile, very serious, and if evidence comes out at the trial that shows that she's liable for more than just manslaughter, they can't go back and prosecute her. So in cases like that, you're going to paper it. And 9 out of 10 times, there's emails back and forth and letters that are written coming to the conclusion of why they're not prosecuting and that they will not be. So you can formulate a deal, at least in writing, by piecing together the correspondence.
So any idea why? Was the lawyer did he forget? I mean, did somebody forget? If it were me, I'd be saying, I want to see this stamped and sealed
With such a high profile.
before I
Yeah.
open my mouth.
Yeah.
Yeah, I don't want to be the Monday morning quarterback for this lawyer trying to look back at what he did, but I suspect they're looking at each other going, I wish we had this in writing.
I bet.
Yeah.
And it's, it was such a high-profile case with so much money on the table that, you've got to be very careful about everything. And we know from the lawyer who is representing the complainant in that case was saying that part of the negotiations in the civil lawsuit was for the complainant not to cooperate with police or prosecution authorities. and they were resisting that. And what they came down to was an agreement not to initiate contact or assistance with them. So one might go, maybe they were thinking that they didn't have an agreement. Who knows? And this certainly fell short. So it was a tough decision for the judge. Extremely interesting, happens in very rare cases, but it's a very interesting argument.
And now they're going to appeal this, though.
They're going to appeal it, but their next step should be and must be to try and exclude all of the depositions from that lawsuit in the criminal case, which would make sense because in Canada you'd be claiming protection under the Canada Evidence Act, and there's certain things called deemed undertakings, and you would not want that to be admissible. And I think they have a good chance at excluding that evidence, but we'll see.
Wow.
So, excluding the evidence from...
The depositions.
Oh.
Yeah, the joke is it's all out there.
It's all out there,
This
yeah.
was released, it's on the internet, it's in the media, everybody knows about it. So, like, it's trying to take the pea out of the pea soup once you made it. But it can't form part, what they're going to try and argue is that it cannot form part of the prosecution case.
Would there be a jury involved in this? The prosecution? If it goes
Well,
forward?
it's typically,
How
in the
would
United
you
States,
act?
it's typically jury. I mean,
How would you find an impartial jury?
I don't know.
Anywhere.
Yeah, right.
You know,
Anywhere in the world,
in the
in
United
fact.
States, everything is in front of a jury, right? You know, impaired driving cases, you know,
Yeah.
small assaults. I mean, it's only Canada where we've really eroded the jury system. So they're going to have to, and they have a much more sophisticated, lengthy process to vet jurors. But good luck.
Yeah.
I mean,
I
can you
mean-
imagine being
Oh, for goodness
the
sake, no.
defense lawyer on that case, trying to, do
They're-
jury selection?
They're
I
going to
mean,
hire psychologists who specialize in jury selection. I don't know. They're going to have to go to some remote town in Alaska where they don't have TVs. I mean, I don't know what they're going to
I
do.
even think in Alaska they know about this. I
I
think
think
they have-
everywhere.
so.
I think they have internet there.
I
so.
think they know about this
Oh, boy.
everywhere. I
It's
don't
gonna
think
be
there's
hard.
anywhere in the world you could go and get an impartial jury on this.
It's going to be very, very tough.
Click the channel subscribe button for full-length interviews and more from What She Said here on YouTube.